Hello, everyone. I'm just going to share my screen quickly. As Corey mentioned, my name is Jonathan Verstein. I'm a lawyer. Primarily, I work with small businesses and I do a lot of estate planning work, and I work out of the Toronto area. Um, Today, what I was hoping to do, like the goal today, is really just to provide everybody with an overview about, wills, just some of the main considerations, and also some of the estate planning process. Not really intended to be a very in-depth detailed presentation. Probably put half of you to sleep if we did that, but it's really more so you get a just a general sense and you're more comfortable with the process if you need to look over your current will, or if you're thinking about doing a will in the future. One thing I do have to say is that just because of the nature of the presentation, really you can't rely on a lot of things that I'm going to say, only in the sense that it may not be specific to your situation. Like, I'm trying to give general information, but um, you know, there's always exceptions, and there's always certain rules that don't apply in certain circumstances. So I just want you to be aware of that. Okay, so today basically what I'm planning to do is just to get some of the terms out of the way. I'll go through some just a few common terms that will come up, just so we have a sense of what they mean. Um, we'll go through like why a will is important, and then just the difference between what happens with certain aspects of an estate plan if you have a will or if you don't have a will. And then we'll cover some of the key considerations. So the executors, the beneficiaries, dealing with minors, and then just an introduction to planning and really what that involves when we're going through an estate plan. And really when we talk about estate planning, really what I'm referring to, like the will is the main document, but it's also things like, considering where your funds are invested, things like, how your property is held, just consideration, just thinking about your property at a broader level and what that means in the future. Okay, so for the term, so I mean, the first one is just, what is a will? So a will is basically it's a legal document, and really the two main things that you're going to do with a will is you're picking your executors, and we'll get through, we'll get to who that role is in a moment, and you're also going to, name beneficiaries and basically tell your executors, what you want them to do with your assets. So one critical thing about a will is that it has very specific signing requirements and witnessing requirements. So the laws have been softened a little bit lately, but for your purposes, it's really important that if you make a will, it's important that you do it with a lawyer, or at least you have some guidance, because it does have to be witnessed in a certain way by certain people in order for it to be valid. And really, when we're talking about witnesses, it's two people have to witness a will, and it's really important that they're not a beneficiary and they're also not a spouse of a beneficiary. So one of the key roles in your will is going to be an executor. They're also referred to as an estate trustee. I'm just going to use executor here. And really what that is the person who administers your estate. And in a slide or two, we'll go through like what that means in some more detail. But think about it as a person who's basically actively dealing with your assets. And then we have beneficiaries, and they're, the people who benefit from your estate. So they're the people that you're going to be giving your assets to through a will. Um, then the two other terms are, one of them is something called a certificate of appointment of estate trustee. Used to be called a probate, and people still use the term probate. Obviously, it's much simpler to say. And what that is, and I'll provide a bit more information after, but really what this is there's in most situations, if a person passes away, their executors are first going to have to make an application to a court. It's a relatively standard application. Some people do it by themselves, many use a lawyer. And really what you're doing is, if there's a will, the court is going to confirm that it's a valid will, and it also confirms who the executors are. Or if there's no wills, it's just going to confirm who the executors are. And what's really important about this document is that's like a notice to the public, like financial institutions, anywhere where you hold assets. This document confirms that those people can deal with the executor. And the last thing I just want to explain is what estate administration tax is. So when a person passes away, there are They have to file tax returns. Sometimes tax comes up. I'm not going to get into those details. That's really the executor goes to speak with an accountant, and that's part of the estate planning processes. Sometimes we'll look at those things. But what the estate administration tax is, this is a separate tax. And when we make this certificate of appointment of estate trustee, when that application is made, and it's only if that application is made, then there's a 1.5% tax on the value of the estate. Okay, and then as part of the will making process, sometimes there's some planning that goes into trying to minimize that. So the next slide is about basically why is a will important? So, I've experienced, there's some misunderstandings or misconceptions. So sometimes people will say, you know what, they don't have enough assets. And, even if you don't have enough assets, I would say, if there's something to pass along, it usually does make sense to have a will. And sometimes people say, or they think that they're not old enough. In my experience, often what I see is over the course of a lifetime, in like a standard situation, usually there'll be a will that people make when they're younger, and then when they get older, they may update their will or replace it with a new one. But there's some really important reasons why younger people should also make wills, and we'll get to that in this presentation. And one thing is that sometimes people have come to me and they wanted to make a will because they were scared if they died that everything would go to the government. So that's actually not the case. It'll come up in the presentation, but they're basically, if you don't have a will, there's certain rules about where your assets will go in it. In simple terms, it'll just be divided amongst close family members. And if you don't have, spouses and children, then it just gets divided between the closest degree of your next of kin. So here are some benefits of having a will. So one is the executor. So basically, you get to pick who the executors are. If you don't have a will, then there's basically a certain order of people who have a right to apply, and ultimately it's almost through the application for a certificate of appointment of a state trustee. They're asking the court to confirm their appointment, and the court will decide yes or no depending on the situation. But the issue there is, of course, that sometimes the people who have the first right to apply, they may not be the people who you really want to be administering your estate, and they also may not be suited. The second is the beneficiaries. So I've touched on this already, but basically, if you have a will, you choose your beneficiaries, and you do have options of choosing a little bit more than that. If you don't make a will, like I mentioned, they're called intestate laws. If you ever hear the word intestate, I guess I should have added that as a definition, but it's basically means when you die without a will, you're intestate. And then what happens is the law will determine who gets your property. And sometimes it has some consequences that people don't appreciate. So one of them is if you pass away and you have a married spouse, not a common law, a married spouse and children, what people don't appreciate is that there's something called a preferential share. So if you don't have a will, the spouse would get the first $350,000 of an estate, but then everything else gets divided between spouses and children. And you get some, if somebody passes away and they have young children, in many cases, this was not, the intention to divide the estate with the child. So it's just something to be aware of. The other thing that's important to be aware of is that if you have a common law spouse, there are some exceptions, but for the most part, you should treat it as if a common law spouse has no entitlement to an estate. So if you don't make a will, then they may not have anything from your estate. Another benefit of a will is, it enables you to better deal with minors. So if you have children or minors that you're caring for, through the will, and I'll show some examples later, you can do things like create trust for them. So when you pass away, some money or a portion of your estate will be held in trust for the child, and we'll set, some terms about how those funds will be released to them. Also, you're able to appoint a temporary custodian or a guardian for the child. So this is important. We always think about these, the scenarios when we're making a will. So one of them, when we're dealing with spouses with children, is what happens if there's a common accident. So in that scenario, you can appoint somebody, if you're a parent, to care for a minor child. And then some other quick benefits. I mean, it simplifies the estate administration process. If you have a will, Your executors, there's some assets that they will be able to deal with right away. They may not have to wait for the certificate of appointment, so it just avoids some complications. And then the last thing is just, the planning component. Even if you don't have a complicated estate, it's just you're going through the process of, about making decisions, thinking about what you have, and then through that process, there's always some planning that you can do. So it's just a helpful process to go through. Okay, so the next slide is about the executor. So here I just want to explain in a little bit more detail, really what the responsibilities are. Um, so really what an executor does is they have to safeguard any of your assets. So if you pass away, if you have a home, just as an example, if you have a home, they're going to make sure that the home is, it doesn't become abandoned and that it's insured and that, there's no issues with the home. They're also responsible for gathering assets. So they'll, write to any financial institutions that you have, or they'll go to the financial institutions and they'll basically move all your assets into, one account. If you have debts or creditors, they deal with those things. They have to file tax returns for you. And then, once those things are done, towards the end of the process, they'll actually pay the beneficiaries in accordance with your instructions or intestate laws if there's no wills. Well, one thing to note is that it's a huge job to be an executor. I should say in some cases, it's a really big job. They are entitled to compensation unless you put something in your will that says that they aren't. And so just important to be aware of that. If they ask for compensation, they're entitled to it. And usually what it works out to, it's somewhere, this is just a ballpark, but somewhere between 3 and 5% of the value of the estate. That's just a rough range of what they're entitled to. And there's basically a very common like court process. If the beneficiaries don't agree to the compensation, then the executor, if they still want it, they can apply to a court. And then the court will essentially review what they did and just decide what's fair and reasonable. Um, so when we're making a will, one really important consideration is who should be an executor. And then, when I'm working with the clients, I think the default to start off with is, whoever is going to inherit the assets, it usually makes sense for them to be the executors if you can. You don't have to appoint the same people, but you can if you want to. So I'll just use the basic scenario where we have a spouse and two children. Often the spouse will receive all the assets of the estate initially, and they would be the, executor. But we always have to consider, sorry, just to go back. So the spouse would be the executor, but we'd say if the spouse can't do it, and if, the children are adults now, we'd say the children would be the backups. But we always have to consider the circumstances. So, maybe the person who normally would be the executor, maybe they have like a language barrier. Maybe there's, sometimes when people get up in age, there may be capacity issues or at least concerns about capacity issues, or just as a difficult job. I mean, you might have to go to banks and people maybe not be so mobile. Those are the things that we think about in deciding who would be an executor. And then, also an important consideration is just convenience. There's other reasons not to, but if just, if you have two children and one is in the country and one lives outside of the country, we'll think about, does it make sense to appoint both of them? Or maybe we'll just do the local one first, and then the one who lives outside of the country is a backup. And then one thing that I come across from time to time, there's some scenarios, listen, where the person just doesn't have anybody that they can pick to be an executor. And sometimes they'll go to like a trusted friend, maybe a trusted friend, or maybe they'll be thinking about a more distant family member. But one thing people don't realize is one option, and it's not for everybody, and it's it depends on the circumstances, but all the major banks have trust companies. So there'll be like a Royal Trust, and it's called Canada Trust for for TD. And basically, this is one of the things that they do. They act as executors. So sometimes I advise clients. Lawyers do it too, but personally, I find that I don't want. I don't know what I'm going to be doing in 5 years, so I don't get appointed as an executor. But some lawyers do. But with the trust company, they're an option. If you don't have anybody, they take a fee. But like I mentioned, executors get a fee anyways. And, that's an option for some people. If you don't have an executor or someone who you're comfortable being an executor, that's an option to consider too. And then, as I mentioned, one of the really important roles for an executor is they have to make this application for a certificate of appointment of a state trustee. And I mentioned earlier, we don't always have to make that application. So really what the process is there's some assets where that application is absolutely required. If you have real estate, other than real estate held jointly, but that's, I don't want to get into that right now. But if you hold real estate by yourself, your executor won't be able to transfer it without the certificate. And then also what happens is when your executor goes to the bank, they might go to the bank and they'll ask to deal with your assets or a person's assets when they've passed away. And the bank will just not deal, they won't permit you to do anything, or they won't permit the executor to do anything until they have that certificate. So that's kind of like the practical scenario, like why the certificate becomes required. Um, oops. So the next topic is beneficiary. So, we've gone through the will process. We've decided who's kind of best suited to actually deal with the estate. And then we have to think about, or you have to think about who's going to actually get your estate. So one thing, as a starting point, there's really two ways that you can leave assets to someone. You could leave a specific gift. So what a specific gift would be, if you have a priceless work of art and you want to give that art to somebody, or if you have some watch that your grandfather gave you and, whatever. You can give specific gifts, or you can give, $10,000 to somebody. The other type of gift is and I would say it's usually you don't always do the specific gifts, but really you would always do the second one. It's called, you would give the residue of your estate, or you would divide the residue of your estate between people. And what the residue is, basically everything that's left over after your executors have dealt with debts and taxes and those specific gifts of property is the residue. And the benefit of dealing with, residue and why we basically always will do it in a will is because, we don't have to identify property. Really, it's whatever forms part of your estate at the time that you've passed away. So, it just simplifies the will process. And then often, people will do things like, well, give my estate to my spouse, and if my spouse dies before me, divide it equally between the children. Or if you don't have a spouse or you don't have children, we'll leave it to two people. And then as part of the will process, what's really important is we always think about alternates. So what happens if, and it's a good thing to think about is, what happens if the person who you've named in your will, if they've passed away before you, what should happen to that gift? And, you could say, well, it's not going to go to anybody in that scenario. It will just be part of the residue, or maybe it goes to their children. Maybe it goes to another person. Um, and that's just part of the will planning process. And I think if you went with, any lawyer, you'll go through that exercise. Um, and then, like, so the things that I've just gone through, I would say that's common in all situations. Like, well, we would always go through those considerations. And then there's always special circumstances that, um, so one is when we're dealing with minor children, and so if you have minors, we'll always create trust for children. You don't, um, you wouldn't, you know, leave like a big chunk of money to a minor for a few reasons. One is they won't even have access to it until they're 18. And second is once they're 18, in many cases, you wouldn't want them to have access to all of it. And I'll deal with that. I'll cover that shortly. Um, one really complicating situation is when we're dealing with second marriages and blended families. So this is a scenario where we have to be a little bit careful because just one example of one of the concerns here is, the default I've mentioned is when people have a spouse is they'll leave everything to a spouse first. But we have to really think about that when we're dealing with those blended families, because there's always a risk that you leave something to the spouse. Um, you had two children who you brought into the marriage. They had two children who they brought into the marriage. You think that the spouse is going to leave it equally between their children and your children, but you pass away and they can change their will and leave everything to their children. You're right. So those are the things that we'll think about, and then we can use just tools called spousal trusts, where Um, you're basically leaving money for the spouse while they're alive, but you're also controlling what happens to it after they pass away. So that's a tool that's used in those situations. Um, one situation that we deal with is if you have a beneficiary, like a child or somebody that you support, and they have a disability. So that's something that, we'll pay some extra attention during the will planning process. And sometimes we'll create what are called, you might hear of a Henson trust or a disability trust, but it's just a form of trust, just designed to make sure that there's some money available to that person, but also that's structured in such a way that they don't become disentitled to disability benefits. And then, some people have children or dependents or beneficiaries who have, financial problems. They, might gamble or have creditors, or there may be substance abuse issues. So those are things that we look at as part of the will planning process. And there's always tools that we can use to, um, to make sure that there's money available for these people, but we also minimize the risk. And it's through creating trust. And before I go on, I just want to confirm is that for trust is sometimes you hear trust and we think of a really complicated a structure. It's not really the case, especially when we're dealing with wills. Um, in a will, we can create a variety of forms of trust, and sure, some of them can be complicated, but some can be as simple as one paragraph or two paragraphs. So it's important to realize that that's a really good option, and it doesn't necessarily have to complicate the will very much. It's just something that we just have to pay some attention to make sure that people are cared for, basically. The next important consideration is those with it's children, but it's also sometimes people are caring for other minors, or they want to make sure that like grandchildren are cared for. So these are some considerations that come up. So I've mentioned trusts already, and I alluded to the fact that we almost always will create a trust for children. And basically, what we're talking about when we talk about these trusts, you can think about it in simple terms as any kind of scenario where what you're trying to do is leave money for somebody, but you want to control how it's used for their benefit and when they have access to it. So it's really when you're trying to exert control over, a pot of money or other types of assets. This is just an example. This is, like a default that I would use with my clients. So often clients who have children, like what we'll say in the will is, divide everything between my children, but if they're under 25, then everything will go to the executor and they'll hold it in trust. And let's say until the child is 21, it's completely up to the executor how much to use for the benefit of the child. Or if they don't use anything for a child, it'll just stay invested. And then maybe when they get to 21, maybe the child will get half of whatever's been being held in trust for them. And then once they get to 25, maybe we get the balance to them. And obviously these are just, you can fiddle around with the numbers and the years and, maybe it goes to them in three portions or all at once when they're 30. It doesn't matter. But this is just, the general structure. And we're just trying to, kind of we don't want, young adults really to, generally to get funds all at once. But again, there's always exceptions. Like, so there's some kids who, you might have a 19-year-old who's more responsible than any adult, and those are scenarios where I've had and I have the parents and they say, look, we're completely comfortable, and that's great. It's your decision, and the beneficiaries better than I do, or better than your lawyer will. So, and then the other thing is custodians. So custodians is like it's the technical term, but really, if you think about the guardians for the child, so. I mentioned this before, but when we're dealing with that common accident scenario, like, it does happen, we have a minor child and something has happened to both parents, what they were able to do, it has to be in the will. And as long as if something happens at the same time to them, they both have to appoint a person, but they can appoint a person who's going to be the guardian for the child. They'll make the decisions for them. They'll be responsible for their care. What's really important to know is that it's only a temporary appointment. It's good for 90 days. And then what has to happen is that person will have to go to the court and then make an application for it to become permanent. And obviously a court will consider the parents' wishes, like that's a very important factor, but they also look at the surrounding circumstances just to make sure, it's ultimately what's in the best interest of the child. So the last part, again, I don't want to get into this part in too much detail. Like when I go, sometimes my poor clients, their eyes glaze over when I get through this stuff. But really when we're making a will, there's some tax planning and there's some other planning, that's involved. And I just want to kind of touch at a high level about some of the things that we're thinking about. So one, I've already mentioned it, but minors, like this is really important for young parents is, just to make sure that, um, there's money available for children, that they've thought about who's going to care for them. This is also where insurance policies come into play. That's obviously for an insurance advisor, but that's a consideration too. The other thing is tax planning. So, um, you know, as we're going through the will planning process, we'll think about sometimes we basically like the way that I do it is I have a form that I send to my clients, and I think most lawyers will do the same thing, and it just lists their main, their assets pretty much. And then that way we have a sense of their assets. And then through the process of reviewing the information and discussing it, we can identify sometimes there's some assets where it's really important to be aware that there might be some tax consequences. So like one main one is, some people have a cottage. If you have the cottage, like that's where there'll be in most cases, there could be a pretty significant tax implication to the estate, right? So it's identifying these things, and then, maybe there's nothing to do. Maybe it just is the way it is, or maybe there's some steps that can be taken to, um, minimize things, or at least make sure that there's money available to pay for it. Another really important part of the planning process, and this is really good for, most people, it has to do with designated beneficiaries. So if you have a TFSA or an RRSP, I'm sure most of you, or at least some of you, I shouldn't assume, but many of you may have a pension benefits. Um, so for these types of accounts and plans, you can designate a beneficiary. And what's really important about that is twofold. Is one that, if you designate a beneficiary for an RSP, for example, it's much easier for the beneficiary to get access to the funds. It technically passes outside of the estate. So they just go to the bank and, there's a beneficiary designation and they show some identification and a proof of death and they're able to get the funds. The other thing is earlier on, I mentioned about that application to the court and the estate administration tax. Because all of these accounts, assuming you've designated a beneficiary, um, they technically pass outside of the estate. So then your estate won't have to pay that 1.5% tax on these amounts, right? So basically using designated beneficiaries gets the money to the beneficiaries quicker, and there's a 1.5%, tax saving, which, it's probably not going to be life-changing, but it's also, it's money. It's probably better off to the beneficiaries than the government. Um, And then the last thing I just want to touch on is life insurance. So, sometimes people have life insurance through work, or they may have a separate life insurance policy. Sometimes, through the estate planning process, we'll always review the life insurance, identify whether somebody has it, and we'll discuss whether anything needs to be done about it. And there's one scenario that comes up is if somebody has minors and basically a minor can't get proceeds of life insurance until they're 18. So what'll happen is, so this is the scenario where, maybe there's two spouses and there's a common accident. So now the backups were the children and now they get the life insurance. But the issue is that they're not going to be able to access the life insurance until they're 18. So there's a document that we can prepare as part of the estate planning process where essentially what we do is we say we override anything that's been named with the life insurance policy itself, and we can do something like designate whoever the executors are can be the beneficiaries of the life insurance plan, and we can say, take the proceeds of the life insurance and then you can use it for the children in trust the same way as the rest of my estate. So just a way to make sure that minors have access to the proceeds of life insurance, that they'll be able to, it'll be used for their benefit before they're 18. So it's just, part of the planning process. And I think that's pretty much all that I wanted to cover. I know we have some time for questions, so yeah, Corey, I'm not sure how like what the process is if you streamline if you manage
Yeah, of
it or if
course.
I
So,
do, but yeah.
yeah, Jonathan, thanks for that. That was great information. As someone that doesn't have a will, this was helpful for me, and I probably should get one. But yeah, I will open up to questions. If you do have questions, please put them in the chat, or if you want to raise your hand on the Zoom function, I can manually unmute you one at a time. So if you have questions, just throw them in the chat or raise your hand on Zoom. Yes, and I see Lee with the first question here. Will you post today's meeting online? So yes, the plan is we've recorded this. We'll be sending it out via email to everyone tomorrow. And we're also going to be posting all of these on our online e-learning platform, which I can safely announce that will be available on the SEIU mobile app next week. You'll be able to start accessing your e-learning on the mobile app. So if you haven't downloaded that, please do. I will start things off with the live questions from Stacy Ann. Make you allowed to unmute yourself. There you go, Stacy Ann. You should be able to unmute yourself.
So is there a way to avoid that 1.5% administration tax, or do you always have to pay that? If you have a will and everything's designated, you still have to pay that?
Okay, so it's whenever the application is made, that tax will come up. There are ways to minimize it. This is where, remember how I said at that little warning at the beginning? This is where if
Mhm.
you're taking steps to try to minimize these things, this is where you really do want professional advice. But I'll give you just a couple of examples. So one is simply by using joint accounts. If just this, the reason I'm using the spouse example, it's kind of the safest one. So if you have a spouse and you have a joint account with them, um, basically, if you pass away, that account automatically goes to the spouse. So it doesn't form part of your estate, and then you don't have to do that 1.5% tax, isn't payable. Using beneficiary designations is another way. Um, for people, this is a little bit more complicated, but people who have corporations, or if they have a business through a corporation, or even people who have, every some people have art collections that's actually worth a lot of money. So there's ways, I don't want to go into this in too much detail, but you can create two wills. And we do one will is for those assets that can pass, that an executor is able to deal with without the probate process or the certificate of appointment of a state trustee. So artwork. If you say give my artwork to somebody, like a beneficiary, like that executor can physically, take that piece of art and give it to your child, and there's nobody really to stop them, unlike a bank account where, it's up to the bank. So those are some ways that we can minimize it. You really wouldn't be able to avoid that 1.5% tax altogether unless you, unless you create a trust, but that's, a trust for all of your assets. But, that's beyond the scope of this. And it doesn't really make sense for a lot of people because you might have to pay tax when you transfer the money to the trust to begin with.
So if you have two people on the deed to your house, does that have to go through, or does that
No.
second person, if I die, because I have a will, but I don't,
Yeah.
that's the first I heard, should I be including that in? Because there's two names on the deed to the
Yeah.
house.
So that's another example of it. So real estate is a little, well, I guess all assets, but with real estate, there's two ways that you can hold property jointly. Usually, and don't quote me on this, but usually when you have, two spouses and they own a property together, it's called joint tenants with a right of survivorship. And what that means is exactly what you mentioned is spouse one passes away, that house will automatically go to the second spouse. They don't need the certificate. It passes outside of the estate, so then you don't pay that 1.5% tax on it. If you hold the property as tenants in common, then what that means is you each have separate interests and it doesn't automatically pass to somebody. The person passed away, their half interest will just be passed through their will, and then it will form part of the estate and there will be tax. And one of the things I mentioned it's important with the joint assets, I said you kind of have to be careful and speak to somebody about this because um, sometimes people will try to avoid that 1.5% tax and they might add a child a joint tenant to their home, which is, fine, which is completely fine, and it's a great thing to do in some situations. But then there's other situations where, maybe there's a rocky marriage, or maybe there's creditor issues, things like that, and it might affect you financially. It also just might be a headache that you have to deal with, and you might have creditors of your child coming to you. So those are scenarios where I would say, be careful with these things.
Yeah, thank you.
All right, we have a couple more. So the first one's from Jason. Are there costs associated with creating the will?
Yeah. So there are, I would say, one option. Well, technically you can write a will when it's called a holographic will. You can make a will with your, handwriting and then sign it. You don't need a witness. So really there's no cost to that. But every time I've come across them, there's been a problem with it because, something was left out. So I'm absolutely not recommending it except in an emergency situation. Um, but if you're going to make a will, there's like anything, there's a huge range. There's online tools that are available, which, that's, you know, the tools themselves are not bad. You just have to make sure that you're comfortable. So there's a lot of online will making tools. And, there's a fairly low cost involved with that. They're often, especially the newer ones, they can be very, easy to use, easy to get done. It's great. The only potential issue with those that you just have to be aware of is that, you just might not, nobody's kind of, they may guide you a little bit, but um, it's always different. Like I find when you have a lawyer or some other professional who's guiding you because, they're able to kind of have a conversation with you and then tease out potential issues, and then you're able to discuss it. So, online will planning tools, they're great for some people. They work with simple situations, but just be aware that there could be some, issues with that. And then when you're going with a lawyer, again, there's a huge range. I mean, what I see in terms of costs is probably between, at the lowest rate range for something simple, you're looking probably about $250 or $300 for a will. Like for me as a starting point, I charge $600 for a will, even for like the most simple one. And then, there's lawyers who will charge 1,000, and up.
Thank you.
And I wouldn't be doing my job if I didn't also say that when Jonathan talked about will planning tools, some of the cheaper ones, if that's in your price range, we do offer some stuff through our Union Savings platform. So if you go to unionsavings.ca, there are some options there for you to take a look at. There's another question here, and Jonathan, I'll just ask. I don't know if you're comfortable with this, but people asked if there's further questions, who do we contact? I don't know if you want to share like your email address or something in the chat if you're comfortable with that. If not, you can send them to communications@sciuhealthcare.ca. I can put that in the chat as well, so that you can follow up with me. In the respective time, and I know we're a little over time, but I want to get to all these questions. I'm going to combine two. So there was two questions that were basically the same. That says, I don't have a will yet, so what happens if I die, or if my spouse is my beneficiary and we die at the same time and we don't have kids? So in a sense where there's no beneficiary, what would happen?
Yeah, so this is where it depends on the situation, but generally speaking, if you're dealing with two married spouses, and if they die at the same time, if it's really the same time and you can't figure out who died first, it's basically they're treated as if, whatever spouse one owned is spouse one's, whatever spouse two owned in their own name is spouse two, and everything they own jointly is divided. And then what happens is it will just go to the closest family member. So this is, I might get this wrong, so don't quote me on this, but this is the rough order. First it goes to children. So first it goes to spouses and children. There's basically a formula. But in our example, there is no spouse. So it would go to children. If there's no children, it would be divided between, so spouse ones would only go to spouse one's parents if they're still alive. If they're not alive, then it will go to spouse one's siblings. Then it goes to nephews, and then, further, more distant relative, like one kind of level at a time. And then I said that, there was one misconception. If there are really no relatives, like a person dies without relative, that is a scenario where their assets would go to the government. But there really has to be like no relatives.
So my message there is, I know SEIU members would want this. Make sure you have a will because you do not want somehow your money to go to Doug Ford. I'll take one more question and then we'll send people on to their Thursday night. Is there a way to avoid probate or make it a better process? How do you prove that a will is the most updated will?
Okay, so avoiding probate. So there are ways to avoid probate. So there, but again, this is where absolutely do not do this without getting professional advice because you could end up with some very upset beneficiaries, which you don't want. But basically, one of the ways is, at least to minimize it, is to hold joint assets. I mean, if you hold all of your assets jointly with a spouse, and there's some scenarios where, maybe somebody's been diagnosed. I'll just give you an example. And I mean, I'm sure some of you at least see this in your day to day. Like somebody's been diagnosed with a lot, not a long term, but like a relatively short term, scenario where they know they have about 6 months. This is very common. They'll just move all their assets into joint accounts and they'll take steps so that when they pass away, there won't be, everything will pass jointly, or they'll give some things away ahead of time to the people that they want to. That's one way to do it. I touched on this before, but just using beneficiary designations or joint accounts is kind of the other way. More complicated is using trusts. There's like tax planning and other planning involving insurance that's used, but I think those are. I would say if you really want to minimize it entirely, speak to a tax or a legal advisor. But yeah, the main ways to just minimize it or reduce it would be through designated beneficiaries and joint assets or jointly held assets.
All right, well, thanks. I just want to, again, thank Jonathan for being here with us tonight, taking your questions and teaching us all a lot about estate planning and wills. This was great. And thank everyone else for joining us. Like I said, this meeting will be emailed out probably tomorrow, so keep an eye on your emails and share with your coworkers so that everyone can get this great information. And then just a heads up that our next one of these financial wellness webinars will be at the same time 3 weeks from now, March 28th at 7 p.m. We're going to be looking at taxes 101. So if you haven't done your taxes yet by the end of March, it'll be a great chance to learn a little bit more about how to increase those refunds or limit how much you owe or whatever your situation is. So hopefully you can join us on March 28th for that. But in the meantime, keep an eye on your emails for this recording.
Hopefully. Thank you.
Have a great night.
You too. Thank you.
Thank you, everyone.
Thank you. Good night.
Thank you. Good night.